Jincy Varughese. I'm an attorney with the Housing and Communities team here at the Legal Aid Foundation of Los Angeles. And I'll be doing this presentation along with and the Q&A portion along with my colleague Ruben Moreno. And yeah, so this presentation will be focused on how to use the small claims process specifically for disaster-related housing issues. And by the end of this presentation, you'll be able to understand your rights as a tenant after the January 2025 wildfire disaster in LA County, for partial or for fully destroyed homes, as well as homes with minor damage. And we'll also learn how to use the small claims process to address wildfire-related legal issues. And before we begin, just a little bit about us. We are the Legal Aid Foundation of Los Angeles. We're a nonprofit law firm that protects and advances the rights of the most underserved. We're aiming to level the playing field and ensure that everyone can have access to the justice system. And we have 5 neighborhood offices, as well as 3 domestic violence clinics, 4 self-help centers, and community clinics. Our legal priorities encompass supporting families, preserving quality, affordable housing, maintaining economic stability, promoting safety, security, and health, serving populations with special vulnerabilities, and protecting human and civil rights. And so first of all, what is a small claims process or a small claims court? It's an expedited and informal court process, and it's really designed for tenants to be able to bring these cases on their own. So a tenant can consult with an attorney about their small claims court case, but they have to represent themselves in the process. So it's designed to resolve disputes quickly and accessibly. Neither party can be represented by an attorney. Plaintiffs don't typically have the right to appeal, and damages are limited to $12,500. So if you believe that, what you're owed or what you should be compensated is under that amount, then bringing a claim in small claims court could be an effective way to resolve that issue. All right, so in the first part of this presentation, we will be discussing your rights as a tenant after the January 2025 wildfire disaster in LA County if you occupy a home that has been fully destroyed or a home with minor damage. And so generally, tenants' rights are determined by both the jurisdiction where the rental property is located, so the city or county, and the type of housing involved. So the laws that affect your tenancy or your unit are different depending on if you live in a single family home, an apartment, a mobile home park, a senior living facility, or subsidized housing. And depending on these factors, your tenancy may be subject to the local rent stabilization ordinance, such as the Los Angeles Rent Stabilization Ordinance, commonly referred to as LARSO, the City of Los Angeles or Pasadena Rent Stabilization Ordinance. Several cities also have just cause ordinances, and there's also a statewide Tenant Protection Act. So if you're unsure what ordinances apply to you, you should contact your local housing department for help in determining what protections apply specifically to your unit and your tenancy. So landlords have a duty to maintain rented properties in a safe condition, and this is something that is called the implied warranty of habitability. This duty is implied in every rental agreement and cannot be waived by the tenant or the landlord. And habitability and violations of this warranty of habitability can be used as a basis for a lawsuit against the landlord in small claims court. So generally, a landlord will only breach the warranty of habitability if they fail to repair conditions they know about or should have known about after notice from a tenant or governmental agency, such as a local housing department or a county public health department. So it's really important that if you are thinking about bringing a breach of warranty of habitability claim in small claims court, to put your landlord on notice of the potential violations of the breach of warranty or potential violations of the warranty of habitability. And for a unit to be habitable under the implied warranty of habitability, a unit must have a roof and exterior walls must be waterproof, so no leaking. Windows and doors must be unbroken. Plumbing and gas systems must be in good working order. Hot and cold running water must be provided. Sewage disposable systems must be operational. Heating equipment must be working properly, as well as electrical lighting and wiring. Floors, stairways, and railings must be in good repair, and the building and common areas must be free of filth, debris, garbage, rodents, and vermin. And so we'll be discussing some differences in what applies when a unit is fully destroyed versus when a unit has some minor damage. So if a tenant's unit is not completely destroyed, the landlord still has a duty to fix the property. And the lease agreement or the rental agreement, that contract remains in effect, even if there are significant habitability conditions or the unit is red tagged by a government agency. And red tagging means that a government agency has decided a unit is not fit for occupancy by a tenant. And if your home was fully destroyed due to the wildfire, unfortunately, that means that the rental agreement, the rental contract has ended. And you don't, and in this situation, you don't owe the landlord any future rent. So this is because under the state statute, the hiring of a thing can terminate by destruction of the thing hired. And so the key question becomes whether a home is completely destroyed or whether the landlord can still repair the property under the implied warranty of habitability. And we'll discuss that a little bit more later. But there's no clear definition of what fully destroyed means. So again, it's important to consult with your local housing department to determine how in that locality completely destroyed would be defined. And the housing department or agency in your area would probably take into consider whether the remaining structure can be realistically restored, and they'll take into account the extent and severity of the damage. So if the unit was fully destroyed by the wildfire disaster, the landlord must return the unused portion of January's rental payment and the security deposit within 3 weeks after the tenant has vacated. So the tenant should notify the landlord in writing that they have vacated due to the wildfire and state what date they moved out. The tenant should also provide a mailing address where the landlord can send the refund check. And if the tenant was behind on rent when the home was destroyed, the landlord can deduct unpaid rent from the security deposit, but they can't, you can't be liable for any future rent after you moved out. And if the landlord refuses to return rent and the the deposit, the tenant can sue in small claims court. And we'll discuss that process a little bit more later. So for fully destroyed homes under the state law, including the Tenant Protection Act, landlords are not automatically required to pay relocation assistance when a unit is destroyed, but the city or county that you live in may have more protective laws that could require a landlord to pay relocation assistance. So again, it's important that you contact your local housing authority to see whether you live in an area that might have one of those more protective laws. And if you do determine that you are entitled to relocation assistance and your landlord failed to provide it, you can again file a claim in small claims court to seek that amount owed. And so now we'll talk a little bit more about homes with minor damage. So if your home was lightly damaged but still safe for living, the tenancy is valid. So your rental agreement continues and you still have to pay rent moving forward. But it's important that you document any poor conditions in the unit with emails, photos, and videos, and always submit your repair request to the landlord in writing. So submit repair requests through text, through emails, and a landlord is still obligated to maintain the safety and habitability of the unit. And in some jurisdictions, so some areas, a landlord's refusal to conduct repairs after receiving a notice could also be considered a form of tenant harassment. And tenants, in addition to violations of the warranty of habitability, if you live in a locality that has a tenant anti-harassment ordinance, you could seek remedies for um, failure to repair and harassment in small claims court. So the city of Los Angeles and also the county, if you live in an unincorporated area of Los Angeles County, you also would be protected under a tenant anti-harassment ordinance. And in some cases, a landlord may ask the tenant to leave the unit temporarily as they make repairs to homes with minor damage. And in, depending on the locality that you live in, a landlord may have to pay the tenant relocation expenses before the tenant needs to leave. So there may be laws that require the landlord to reimburse you for any hotel expenses or any expenses incurred for finding that temporary stay. And the amount, again, would depend on the local ordinance in effect or the state law in effect, and a tenant may have a right to return. And if a landlord seeks to displace a tenant due to repairs, it typically can't just be a tenant has to be out the next day. They have to provide notice in writing, and it will usually be 30 or 60 days notice. And if your landlord is not providing you relocation assistance that you're owed under law, you can try to seek that in small claims court. If the home had minor damage, but the tenant wants to leave the unit, you should provide at least 30 days written notice to your landlord, or also check if your lease um, requires longer notice. If the tenant wants to leave in the middle of the lease, and you should try to find a replacement tenant. So the landlord may hold you responsible for the rest of your lease term, unless for that unpaid rent, unless you're able to find a replacement tenant. And you may be entitled to break the lease agreement if your landlord refuses to repair your unit. And it's important that in these situations, you fully document all the conditions and requests, and provide an opportunity for the landlord to repair the issues. So next, we'll be discussing a little bit more about the small claims process. So as we discussed, if your tenant rights were violated as a result of the wildfire disaster, you may seek remedies through small claims court. But before you officially start the process, it's important that you make a formal demand, either orally or in writing, but in writing is always best, so you can refer to this in your small claims court record. And if you didn't explain, or if you didn't make a formal demand to your landlord, you will have to explain why you didn't in Section 4 of a form called SC 100, which is one of your first forms that you'll have to file in court. And this formal demand that you make to the landlord has to state how much you're owed, when the landlord should pay you by, and how they should pay you. And you should give the landlord a reasonable amount of time after you make that formal demand to respond, typically 7 to 14 days. And if you're unsure how to find what your landlord's contact information is. You should review your lease agreement to find, your landlord's phone number or email address, phone number, address. And if you don't hear anything or they refuse, you can move forward with filing an action in small claims court. So once you're ready to file in small claims court, you'll need to complete at least 3 documents. The first one is called a plaintiff's claim in order to go to small claims court. And it's called SC 100, so small claims form 100. And if there are multiple defendants, so if you are suing multiple entities, for example, if your landlord is an LLC and you find out that um, there's another entity, corporate structure, or yeah, corporate entity that owns that LLC, you may want to sue both the LLC and the other entity that owns the LLC. But you'd have to fill out this extra form SC 100A. You'd also have to fill out MC 31, which is an attached declaration that explains why you're suing, and it should detail all the facts related to your demand. The other form that you would want to fill out is fee waiver 1, which is a request to waive court fees. And that basically allows you to have to waive filing fees. So each document you file would have a specific cost, and this would allow you to have 0 costs when filing. And yeah, you'd also need to figure out which courthouse to file in. And so the Superior Court of California, um, County of Los Angeles has a filing court locator that will help you determine which courthouse you should file your small claims action in. And it's really based on zip codes. However, if you've moved from your rental unit where you have fire-related claims at, your current zip code might not be the relevant zip code to use when figuring out which courthouse to file in. It will likely be the zip code of your address where your unit had fire damage. And there's a specific section of the small claims form which helps you figure out which courthouse to file your small claims action in. And we recommend that you file your complaint in person with the small claims court, but some courthouses do accept filing via fax, and it's best, yeah. We recommend doing it in person because in case you have to modify your documents, edit them, the small claims clerks should be able to assist you with that. And once you file the documents, you'll receive a hearing date and case number from the clerk. And typically your hearing date will be 3 to 4 months out from the date that your complaint is filed. And both you, the plaintiff, the person suing, and the defendant, the person who you're suing, can request the hearing be postponed if either party has a good reason, and the form to use is SC 150, request to postpone trial. And the defendant must be served with the small claims documents, and service just means that you are in some way providing these documents to the defendant. But there are very specific rules on how those documents should be delivered. Um, so the plaintiff, cannot serve the defendant. It has to be a non-party. And the ways that you can serve are hand delivering it to the defendant by a non-party, so someone who isn't you, who is 18 and above who's 18 and above. You can also have the Los Angeles County Sheriff do this, and the courthouse can help you do this. You just have to pay a fee to have that done. You can also serve through substituted personal service. So say you can't reach the defendant, you may be able to serve another person, as well as you'd have to mail it to that same address. You can also serve by certified mail, And the court clerk, when you're filing your documents, can also help you do that. You will just have to have a return receipt requested. And the defendant has to be served no later than 15 days before the small claims hearing date. And depending on the method of service and where the defendant lives, for example, if they live outside of LA County, you may have to serve them even further in advance, so 20 to 25 days before the hearing. So the person who serves the documents has to fill out a document called a proof of service. And that's on a specific form, which is SC10 form. And the plaintiff has to file that proof of service with the court in person or by fax at least 5 days prior to your small claims hearing date. And if the sheriff department serves a defendant, they will file that proof of service. And it's really just letting the court know that you have in fact, provided those documents to the defendant. All right. And so next you can move on to preparing for your hearing. And you'd want to gather the evidence to support your claims. So documents, receipts, letters, emails, text messages, photos, videos, witnesses, etc., particularly for, habitability claims. You would want, and, if you're requesting the security deposit after vacating or requesting the remainder of January rent, you'd want to have photos and videos showing the poor conditions, showing the conditions of the premises when you left. Both plaintiff and the defendant can bring witnesses with them on the day of the hearing. And if you need to subpoena a witness, so maybe you want to have the housing department as a witness, you would have to subpoena them and you would use a specific form, SC-107. Otherwise, your witnesses can join you on the hearing day without having to file anything with the court. And you should just be mindful of the volume of evidence you intend to present in your hearing, as small claims hearings are not like trials in civil court. These hearings are typically very quick. And you have to exchange and submit your evidence with the court 10 days in advance. So submit it to the court, but also exchange it with the defendant. And you have to show that you did exchange it with the defendant. There's a specific form that you'd have to file, which is LASC form 278. And that just lets the court know that both parties are aware of the evidence that the other side is going to present. And you must exchange the evidence via mail and also have that proof of mailing to show the court that you've exchanged the evidence. Right. And so when you attend your small claims hearing, you should bring 3 copies of all of your evidence with you. So a copy for yourself, the judge, and the opposing party. And as the plaintiff, you have the burden of proof. So this means that you have to have enough evidence to prove to the judge that what you claim happened is true and the amount of money that you're owed is correct. And your small claims hearing is a formal court hearing. And so just be mindful of, dressing appropriately, addressing the judge respectfully, and just not interrupting others when they're speaking. And the judge will make a decision on the matter. In most cases, it might not happen right after the hearing, but it may happen several days or a week after the hearing where the judge will issue a formal decision. And that decision will be mailed to you. So keep your mailing address up to date with the court. If you won, if the judge decides that the defendant, your landlord, owed you money, then you may proceed with collecting and enforcing the judgment. The defendant may decide to appeal the decision, and in which case you wouldn't be able to collect the money. You would have to wait for that appeal to be heard. And if you lost, the judge decides that the defendant does not owe you money, then you don't get anything and you can't file a claim on this issue again. So it's really important that when you bring it, you have all your evidence, you have your witnesses ready, because if you lose, it can preclude you from bringing it again. And And this is just an overview, a chart that provides an overview of the small claims process. So first, you're making your demand, your informal demand to the landlord. Then you file the complaint, you serve it on the defendant, file that proof of service. Then you do your pre-hearing investigation, gathering your evidence, drafting your statements, subpoenaing any witnesses if you need to. And in the hearing, you should bring all your evidence, prepare an oral statement, prepare, why you believe the landlord breached the warranty of habitability, why you owe the amount of money you claim you're owing, um, interview or call your witnesses, and the landlord will make the hearing or will make a decision after the hearing. And then post-hearing, a judgment will be entered indicating that you've won or that you've lost. And then if you've won, like we discussed, it will be up to you to try to collect that payment. And that's all for our presentation.